But there's a gulf between not affirming and acquitting. I mean, we could not affirm and send it back, and then maybe the Second Circuit says there has to be a new trial on whatever other theory the government has.
Well, Justice Jackson, that would only make sense if it were permissible under the rules of procedure and the Constitution for the government to get that second bite at the apple. And in a case like Ciminelli, which is pretty much on all fours with this case, the court simply entered an opinion that said reversed. It didn't remand for anything else. Ciminelli involved the financial printer who was charged and convicted of defrauding innocent market traders based on information that he stole from the print shop about upcoming financial transactions. The court said that's not a valid theory of insider trading because it doesn't involve fraud. The government came back and said, yes, but he stole the information from the print shop in breach of an established fiduciary duty and agency relationship, and that constitutes everything you need for an insider trading violation, which, by the way, this court later held in United States versus O'Hagan. But the court said we cannot affirm a criminal conviction on the basis of a theory not presented to the jury, and the judgment was reversed, and Ciminelli went free. And that is the same, I think, result that should occur in a case like this one. The government's new theory, beyond all of its other flaws, was not charged in the indictment. The government is actually asking the court to entertain in a theory that would create a constructive amendment of the indictment.
But you don't charge theories. I mean, the government charged the statute, violation of the wire fraud statute, and it went to trial on a particular theory as to how that was accomplished, but I think the indictment is not defective, is it?
Yeah, the indictment actually is defective, Justice Jackson, because it's not enough, at least in a case like this where the government says what the property interest is. There is a theory of the indictment, and the government has to prove the theory that it charged, not a different theory. And that is particularly true in this case because the indictment specifically charges the right to control its assets as the property interest, and that was not an accident. The government originally had an indictment in which it did charge that the ultimate state-awarded contracts were the property interest, the same thing that my friend now says is the property interest. But there was a case in the Southern District of New York called United States versus Davis, in which the government had gone to trial on a similar indictment that charged a contract as the property interest, and then it tried to save the conviction by pointing to the right to control theory, which is very vast and nebulous. And the district court said, you cannot do that. That would be a constructive amendment of the indictment. So what did the government do? It went back and it changed from the first superseding indictment to the second superseding indictment to delete contract funds as property and to substitute the right to control. And you can see that most clearly in a red line document that the government filed with the court, which is docket entry 319-2, which contains a red line of the differences between the two indictments. And you can see that the government redlined out that the scheme to defrauded Fort Schuyler of, now I'm going to read the stricken language, an award of significant taxpayer-funded development contracts. And it substituted in defrauded Fort Schuyler of its right to control its assets and thereby exposed Fort Schuyler to the risk of economic harm. So the government didn't just not charge this theory or not charge any theory. It put the defendants on notice, it put the court on notice, and it repeatedly relied on right to control rather than a property fraud conventional theory to exclude critical defense evidence. And I think when you have all of those features, whether it adds up to a formal waiver or as the kind of abandonment of a new theory that should foreclose the government from getting its second bite at the apple, I think it adds up to an acquittal.
Well, whether